Dear guests, welcome to the second day of our conference, Innovation of University Teaching in a Digital, Multilingual and Globalized Society, a perspective from the project CALESA. This event has been organized within the scope of the Erasmus Plus program project, CALESA, standing for Capacity Building for Legal and Social Advancement in the Philippines, supported by the European Union and coordinated by our dear partners from the University of Malaga. Before starting, we kindly ask you to fill in our satisfaction survey. You may access it through the QR code that you can find at your table and at the door. This is important to guarantee the quality indicators of our project. Thank you. To start our second day of activities, we welcome to the stage Professor Margarida Lima Rego, who will moderate the panel session entitled Modernization of Law and Legal Education in a Digital World. Margarida Lima Rego is an associate professor with aggregation and vice dean of Nova School of Law, where she has regularly been teaching since 2005. As an academic, she has coordinated a number of disciplines and published on a wide range of private law topics with special focus on contract law. Currently, she is responsible for the subjects of law of obligations and insurance law. Her main areas of practice are civil and commercial law. She was of counsel at Moraes Leitão, where she coordinated the transversal group of insurance, reinsurance, and pension funds, having left the firm in July 2019 to dedicate herself fully to her academic career. As a lawyer, she regularly advised national and international clients from the public and private sectors in the design and implementation of various commercial operations and in the composition and negotiation of various contracts, with special focus on the insurance sector. As a legal consultant, she is regularly consulted on various matters of Portuguese and Lusophone law, having contributed to the resolution of disputes before the courts of various jurisdictions. She is also the president of AIDA Portugal and a member of the executive committee of AIDA Europe and the presidential council of AIDA World. She is president of the Portuguese section of the Law and Commercial Practice Committee of the International Chamber of Commerce. Thank you.
Hello and good morning. It is my job to introduce our first speaker. Unfortunately, our first speaker could not be here with us today, so he will have a recorded presentation. And to represent him on this panel, we have attorney Miguel Romualdo Sanidad, who will be here to answer questions if there are any. So the first speaker is Justice Alfredo Benjamin Sabater Cagioa. He is the 174th Associate Justice of the Supreme Court. Prior to his appointment on January 22nd, 2016, Justice Cagioa began his government service in the Executive Department, serving as Secretary of the Department of Justice and Chief Presidential Legal Counsel to former President Benigno Aquino III. As DOG's Secretary and Attorney General of the government, Justice Cagioa rendered legal advice and opinions to government agencies and to government-owned and controlled corporations. At the DOJ, he introduced reforms to streamline the agency's operations and improve the quality of DOJ's services to its stakeholders. He exercised supervision and control over the offices of the DOJ and exercised administrative supervision over DOJ-attached agencies, such as the National Bureau of Investigation, Bureau of Immigration, Bureau of Corrections, Public Attorney's Office, and Office of the Government Corporate Counsel. He also chaired the Interagency Committee on Extralegal Killings, Enforced Disappearances, Torture, and other grave violations of the right to life, liberty, and security of persons, as well as the Interagency Council Against Trafficking. Prior to joining the government, Justice Cagioa had 2.5 decades of experience in litigation and arbitration. Justice Kagioa taught obligations and contracts, property, statutory construction, and administrative law at the Colleges of Law of Ateneo de Manila University, University of Santo Tomas, and San Sebastian College. Justice Kagioa obtained his degree in economics honors program from the College of Arts and Sciences of Ateneo de Manila University in 1981, honorable mention, and graduated with honors from its College of Law in 1985, ranking 5th in his class. He was admitted to the Philippine Bar in 1986 after placing 15th in the 1986 bar examinations. He is currently the chairperson of the Subcommittee on Integrated Bar of the Philippines Oversight and the member of the Subcommittee of the Revision of the 1997 Rules of Civil Procedure. We will now begin to hear and see him speak by the recording just starting. Thank you.
Buenos días, señores y señoras. Es un honor haber sido invitado a hablar en este encuentro de expertos. Yo estaba verdaderamente animado y motivado a estar allí en persona para dar esta conferencia, así como también conocer a muchos de ustedes. Desafortunadamente, algunos casos fortuitos me han impedido realizar el viaje. I hope that sounded well. The Philippine legal system, as it exists today, rises from its protracted colonial history and illustrates the unique amalgamation of civil law and common law, born of over 3 centuries of Spanish colonization and nearly half a century of being under the American colonial regime. When Miguel Lopez de Legazpi set foot on the island of Cebu in 1565, Spain's 333-year rule over the Philippines began, ushering in a legal system grounded on Spanish legislation, which was then adopted in the Philippines by way of extension. Of particular mention are the Siete Partidas, which, as its title suggests, is a 7-part compilation of Roman law modified by local Spanish custom. The Laws of Toro, which dealt mostly with succession. La Novísima Recopilación, or the new compilation, which touched upon all branches of law, and the laws of the Indies, which adopted a system of colonial legislation. While the adoption of Spanish law pushed forth a significant transition from the fragmented customary law that governed the Philippines, the specific means by which they were intended to operate were far from clear. In the words of Spanish economist and diplomat Sinibaldo Dema, the lump sum adoption of Spanish legislation in the Philippines resulted in a vast sea in which are found abundantly the resources necessary to mix up matters and stultify the course of justice. This confused state of the legal system prompted a call for reforms in the late 1800s. As noted by prolific author, esteemed scholar, and my dear friend, the late Professor Ruben Balane, the most notable statutes resulting from this major overhaul were the Código Penal, introduced in 1887, the Code of Commerce, introduced in 1889, and of course, the Código Civil, also introduced in 1889. The significance of these codes is clearly illustrated by the fact that they remained firmly entrenched in the Philippine legal system even after Spain ceded the Philippines to the United States in 1899 when the Treaty of Paris was ratified. This may be attributed in large part to the explicit instructions given by then United States President William McKinley to the commander of the Army of Occupation General Wesley Merritt to maintain the main body of laws which regulate the rights and obligations of the people with as little interference as possible. Particularly in the field of civil law, the continued effectivity of the Código gave rise to a body of jurisprudence anchored heavily on the Spanish tradition and influenced by the likes of Manresa, Sanchez Roman, Castan, and Cévola, to name a few. In 1950, the provisions of the Código Civil were carried over almost verbatim and adopted as the Civil Code of the Philippines, keeping the Spanish law tradition in the Philippines very much alive. To this very day, Philippine substantive law on property, ownership, succession, obligations, and contracts still trace their roots back to Spain, specifically within the nooks and crannies of the Código Civil. Be that as it may, the American occupation brought about a new body of commercial law, which is essentially superseded the Spanish Code of Commerce. This is the Corporation Law of 1907, the Chattel Mortgage Law of 1906, the Insolvency Law of 1909, the Negotiable Instruments of 1911, the Insurance Act of 1914, and the Usury Law of 1916, to name a few. These statutes were introduced by the Americans to keep commercial law up to date and responsive to modern economic life. Economic development sparked a movement which signaled the rapid incorporation of Anglo-American common law in Philippine jurisprudence. From this confluence arose a unique legal system, described by Justice George Malcolm as a result of two great streams of the law, and I quote him, "The civil, the legacy of Rome to Spain, coming from the West, and the common, the inheritance of the United States from Great Britain, amplified by American written law coming from the East," close quote. Thus, in the early 1900s, the Philippine Supreme Court, then composed of 6 magistrates, majority of whom were American, were given the difficult task of applying and reconciling a hodgepodge of laws originating from two legal traditions that are as well established as they are fundamentally different. Today, 70 years after its enactment, considerable portions of the 1950 Civil Code have been repealed or amended by piecemeal legislation. For instance, in 1987, Executive Order number 209 known as the Family Code of the Philippines, was signed into law. The Family Code repealed several portions of the Civil Code, including the titles on marriage, legal separation, rights and obligations between husband and wife, property relations between husband and wife, the family, paternity and filiation, support, parental authority, and emancipation and age of majority. Changes in the Family Code were introduced while taking into account the developments that necessitated the revision of the Civil Code provisions on marriage and family relations to contextualize them within Filipino customs, values, and ideals, and reflect then contemporary trends and traditions. The Family Code also aimed to reflect the policies embodied in the then newly ratified 1987 Philippine Constitution, which strengthens marriage and the family as basic social institutions and ensures the equality of men and women before the law. Labor standards and relations in the Philippines were also previously governed by the Civil Code and special laws. Recognizing, however, that relations between labor and capital are considered not merely contractual in nature, but impressed with public interest, Presidential Decree number 442, known as the Labor Code of the Philippines, was enacted in 1974, carving out matters concerning labor and employment from the sphere of law governing ordinary obligations and contracts. Then, more recently, in 2018, the provisions of the Civil Code on pledge, mortgage, and antiquities, as well as the concurrence and preference of credits, were also amended by Republic Act number 11057, otherwise known as the Personal Property Security Act. This act aims to strengthen the secured transactions legal framework in the Philippines by establishing a centralized notice registry and providing mechanisms for enforcement of security interests in personal property. Perhaps owing to the fragmented approach taken with respect to matters concerning civil law, several areas in the field remain subject to provisions that have inevitably become passé and obsolete through the development of new socio-political paradigms. One notable example is in the realm of family law. When the Family Code took effect on August 3, 1988, it was nothing short of revolutionary for its time, having been enacted in light of, and I quote, pervasive changes and developments in society and in order for the law to reflect contemporary trends and conditions. And yet, some of the Family Code's provisions are now perceptibly out of tune in light of the provisions of the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW, to which the Philippines is a signatory. As a state party, the Philippines is bound to, and I quote, take all appropriate measures to eliminate discrimination against women in all matters relating to marriage and family relations, close quote. And to guarantee, on the basis of equality of men and women, the following, among others. 1, the same rights and responsibilities during marriage and at its dissolution. 2, the same rights and responsibilities as parents, irrespective of their marital status in matters relating to their children. And 3, the same rights and responsibilities with regard to guardianship, as well as the ownership, acquisition, management, administration, enjoyment, and disposition of property, whether free of charge or for a valuable consideration. The state's obligations under the CEDAW mandating equality between men and women are currently in clear conflict with the Family Code, which still accords the husband preference or priority over his wife with respect to important decisions affecting the family, the children, and the administration of property, particularly in case of disagreement. In fact, both the Commission on Human Rights of the Philippines and the Philippine Commission on Women have observed that the family code is now in need of updating and have in fact advocated for the amendment of the provisions which are viewed to be discriminatory against women. Among these are Article 14, which gives preference to the father's consent to the marriage of children between ages 18 and 21. Articles 96 and 124, which give preference to the husband's decision in case of disagreement in the administration, enjoyment, and disposition of community property and conjugal partnership property, respectively. And Articles 211 and 225, which give preference to the husband's decision concerning the common children and the legal guardianship of an unemancipated common child. While this statutory preference has been justified to be an intermediate modus vivendi or practical compromise, it now operates as a mechanism to reinforce gender stereotypes by regarding the husband as the decisive head of the family and giving the latter preferential treatment on the basis of sex. Yet another area that reveals a distinction that may be reasonably deemed in conflict with the Philippines' international obligations is the remaining classification of children based on the status of their parents at the time of their birth. As such, the differential treatment between legitimate children and illegitimate children, or those born outside of a valid marriage, results in varying rights with regard to the use of surnames, the establishment of paternity and filiation, and succession, among others. Through the years, this differential treatment has come in conflict with the Philippines' obligation to respect the rights of children without discrimination of any kind, irrespective of birth or other status, as provided under the United Nations Convention on the Rights of the Child. Two, there has been a clamor to pass a law permitting divorce in the Philippines, as it is the only other country in the world, apart from the Vatican, which has not adopted a law recognizing absolute divorce. Moreover, aside from the provisions that must be reassessed in light of changes in the socio-political climate, some provisions of the Civil Code, which provide for threshold amounts, have been rendered obsolete by the mere passage of time and inflation. Notably, the application of several Civil Code provisions remain hinged on fixed amounts set in 1950, when the Civil Code was enacted. Since then, inflation and the resulting depreciation of the Philippine peso through the years have effectively rendered these fixed thresholds obsolete. Among these are Article 704, governing the abatement of nuisance, which allows a private person under certain conditions to abate a public nuisance which is especially injurious to him, without resorting to judicial proceedings, provided that the value of the destruction does not exceed 3,000 pesos, which is roughly $60 today. Article 748, governing donations of movables, which requires the donation and acceptance of personal property with a value exceeding 5,000 pesos, which is roughly $100, to be in writing as a condition for validity. Article 1358, prescribing the form of contracts, which requires all contracts exceeding amounts exceeding 500 pesos, again roughly $10, to appear in writing. Article 1403, or the Statute of Frauds, which requires agreements involving the sale of goods, chattels, or things in action at a price of not less than 500 pesos or $10, to be in writing and subscribed by the party charged as conditions for enforceability. Article 2206, governing damages, which sets the amount of 3,000 pesos as the minimum amount to be awarded for death arising from a crime or quasi-delict. As well, it cannot be denied that technological innovation poses a constant challenge to the historically rooted provisions of the Civil Code. The internet has, for a fact, changed the way people access information, communicate, and interact. With the developments of more advanced platforms for communication and publication, which were not contemplated in the 1950s, comes the rise of a greater demand to revisit the utility, practicability, and efficiency of the provisions on notice, publication, and access to records. One such provision is Article 63 of the Civil Code, which requires print publication in the official gazette or in a newspaper of general circulation as a requisite for effectivity of statutes. This provision has been made subject of several bills pending with the Philippine Congress, which propose to allow publication through online versions of the official gazette of the Republic of the Philippines or through official electronic channels of concerned government agencies in order to recognize the shift towards digitization. Now, in response to the apparent incongruities between the Philippines' historic laws and its present exigencies and international obligations, strides have been made on the judicial front to fill in legislative gaps and keep the law abreast with the times. In Aquino versus Aquino, the court touched upon the impact of the prevailing classification of children on the issues of filiation and succession. There, the court revisited Article 992 of the Civil Code, which sets a barrier, or what we call here the Iron Curtain, that prohibits intestate succession or succession ab intestato between the illegitimate child and the legitimate children and relatives of the father or mother of said illegitimate child, who are themselves legitimate. This Iron Curtain is historically based on the presumed antagonism and incompatibility between the illegitimate child and the legitimate family. Recognizing the Philippines' obligation to uphold the best interests of the child under the UNCRC, the court, in this case, abandoned the Iron Curtain rule and held that illegitimate children should be allowed to inherit from their grandparents and other relatives. In so ruling, the court emphasized that it is the illegitimate child who suffers from the consequences of Article 992, despite the fact that they are classified as such without their fault. To avert this outcome, the court ruled that an illegitimate child's right of representation should be governed not by Article 992 of the Civil Code, which enshrines the Iron Curtain rule, but by Article 982 of the same statute, which allows grandchildren and other descendants without qualification to inherit by right of representation. Another case, the recent case of Republic of the Philippines versus Manalo, dealt with the recognition of foreign divorce. There, the court had the occasion to determine whether a divorce obtained by a Filipino based on the national law of the latter's foreign spouse could be recognized in the Philippines. This directly put in issue the scope of Article 26 of the Family Code, which provides that, and I quote, where a marriage between a Filipino citizen and a foreigner is validly celebrated, and a divorce is thereafter validly obtained abroad by the alien spouse, capacitating him or her to remarry, the Filipino spouse shall have capacity to remarry under Philippine law, close quote. The language of Article 26 suggests that it only permits recognition of foreign divorce in instances where it is obtained by the alien spouse. In the end, however, the Supreme Court placed primacy on the legislative intent to treat Article 26 of the Family Code as a corrective measure to address anomalous cases where the Filipino spouse remains tied to the marriage as a consequence of the Philippine prohibition against absolute divorce, while the foreign spouse is deemed free to marry under the laws of his or her country. With this in mind, the Supreme Court found it unreasonable to interpret Article 26 as a mechanism to recognize foreign divorce only in instances where said divorce is obtained by the foreign spouse. Such limitation, said the court in this case, proceeds from a superficial, arbitrary, and whimsical classification between Filipinos and foreign nationals. Thus, noting that a favorable decree dissolving the marriage bond and capacitating the foreign spouse to remarry leads to the same result regardless of the party who initiates the divorce proceedings. The Supreme Court applied the Equal Protection Clause and ruled that a Filipino who initiates a foreign divorce proceeding is in the same place and in like circumstance as a Filipino who is at the receiving end of one initiated by the latter's foreign spouse. Consequently, Article 26, which provides the sole mechanism for recognition of foreign divorce in the Philippines, should not be interpreted as making such a distinction. Another case, People versus Hugueta. Here, the Supreme Court, in recognition of the financial fluctuations over time, increased the standard amounts for civil indemnity to be awarded in relation to certain crimes. The Supreme Court reasoned that since Article 2206 of the Civil Code merely imposes a minimal amount for awards of civil indemnity, then, and I quote, the amount awarded as civil indemnity can be validly modified and increased by the court when the present circumstance warrants it, close quote. This sampling of recent cases illustrates how legislative gaps have confronted the Supreme Court through threshold questions that go into how common law may, if proper, and by way of international conventions, be infused or otherwise incorporated in the Philippine civil law system. They demonstrate how the confluence of civil and common law traditions in the Philippines, which took place more than a century ago, set the foundation for the development of a body of jurisprudence that is robust and responsive to the unique challenges of our time. This dynamism is perhaps one of the most notable characteristics of our mixed legal system. Nevertheless, such dynamism, while laudable, is fraught with its own dangers. What prolific author Jose Velez Torres has said about Puerto Rico's civil law tradition holds true for our own. While civil law, in the context of a mixed legal system, completes and perfects itself through jurisprudence, the danger lies in the introduction of foreign ideas into the civilian tradition in cases where the civil code already presents a solution. This danger is magnified in the Philippine context, where a tripartite division of powers exists among the three branches of the government: the executive, the legislature, and the judiciary. Unlike in purely common law jurisdictions where judges assume a lawmaking role, members of the Philippine judiciary are tasked to apply the law as it is written. The confines of judicial authority thus preclude the Supreme Court from engrafting upon the law, and I quote, something that has been omitted, which someone believes ought to have been embraced. Hence, while the Supreme Court is not blind to the significant challenges that shifting norms and values have posed upon the foundations of its civil law tradition, it cannot override statutory law based solely on what it believes our norms and values should be, lest it tread dangerously into the realm of judicial legislation and cause erosion of the Philippine civil tradition. This difficulty is best illustrated in the recent case of Ordoña versus local civil registrar of Pasig, which involved a petition for cancellation or correction of entries filed by a mother concerning entries appearing in her child's birth certificate. In the birth certificate in question, the child's last name was indicated as that of the husband's. While the woman acknowledged that the child was indeed another man's son, she nevertheless sought to change her child's last name to hers. As well, she asked to delete the paternal information pertaining to the other man on her child's birth certificate. The Supreme Court viewed the desired correction as one which affects not only the clerical entry on the child's certificate of live birth, but more so going into matters of legitimacy and filiation, since the child is presumed to be the legitimate child of the woman's husband under Article 164 of the Civil Code. This is so because the marriage remained valid and existing at the time the child was born. In effect, the case called into question the application of Article 167 of the Civil Code, which provides that the child shall be considered legitimate even though the mother may have declared against its legitimacy or may have been sentenced as an adulteress. Ultimately, the court dismissed the case, since Article 167 effectively bars the woman from impugning the presumed legitimacy of her own child. The court pointed out that under the Civil Code, it is only the husband, and in certain cases, his heirs, who possess the right to dispute the legitimate status of a child. By its pronouncements in this case, the court nevertheless acknowledged that Article 167 left both the mother and the child without any remedy to establish the child's filiation with the latter's biological father. The court also recognized the apparent disparity between the mother and the father's legal standing in assailing the legitimacy and establishing the filiation of a child. In all, the Supreme Court recognized the lacuna in the law, a gap which remained even with the amendments introduced by the Family Code. Bound by the letter of the law, the Supreme Court exercised judicial restraint and dismissed the petition in Ordoña. Nevertheless, the court called upon Congress to address the incongruity between domestic law and the Philippines' obligations under CEDAW to eliminate discrimination against women, particularly in all matters relating to marriage and family relations. As this case of Ordoña highlights, the tides of time and shifting political currents have created numerous legislative gaps that are coming into fore. These gaps remain despite several attempts to close them by way of piecemeal legislation. As these legislative gaps grow wider with the passage of time, it becomes imperative to recognize that meaningful reforms in the field of civil law cannot be achieved through a fragmented piecemeal approach. Rather, the profound shift in societal norms and values call for a reassessment of the fundamental principles that form the basis of our 72-year-old Civil Code, with the view of effecting its wholesale amendment. This wholesale approach is hardly novel in mixed jurisdictions. In 2020, Puerto Rico caused a holistic amendment of the Civil Code for the first time since 1930. The salient changes introduced by such amendment included: 1, the revision of the definition of marriage as a civil contract between two natural persons; 2, the recognition of mutual consent and irreconcilable differences as grounds for divorce; 3, the recognition of the spouse's common right to claim preferential allocation of the family residence at the time of the dissolution of the marriage based on financial capacity; and 4, the recognition of the children's right to receive compensation for damages arising from lack of voluntary and timely parental recognition. Another example is the Civil Code of Quebec, which came into effect in 1994. This code replaced the Civil Code of Lower Canada, which had been enforced since 1866, and introduced major reforms to 1, promote economic equality between spouses, 2, enhance the modes of exploiting property and wealth, 3, increased security afforded to property rights to promote commercial transactions, among others. Clearly, therefore, Philippine civil law is now at a crossroads. It's a situation reminiscent of the state of affairs that sparked the legislative overhaul that gave rise to the adoption of the Código Civil in the late 1800s. Now, more than ever, it is necessary to recognize what our legal history so clearly illustrates, that the situation lies in the wholesale amendment of the Civil Code. As these exemplars of Puerto Rico and Quebec show, meaningful reforms must proceed from deliberate and definitive policy decisions that determine which norms and values most accurately reflect the collective will of the people. Decisions that can be made only through the turning of the legislative mill. In the same vein, but conversely, it may be reasonable to suppose that if the judicial efforts were to be the sole mechanism through which these gaps will be closed, it would amount to no more than an erosion of the civil law system via judicial legislation, as opposed to a straightforward and clear-eyed re-examination thereof for purposes of appropriating the same along the nuanced contours of our local national life. It goes without saying that the former is not permitted by the present constitutional restraints and design of the judiciary, while the latter is no less than the sole requisite if our nation is to have its best chance at navigating the way forward with a civil law that has both the stability of its historical moorings as well as the flexibility to turn and meet the inevitable winds of change. Once more, and I say this in English, I am grateful for the honor of an audience with all of you. I thank the capacity building for legal and social advancement in the Philippines, the CALESA project of the European Union's Erasmus Plus program, as well as the Nova School of Law for hosting today's conference. Perhaps now, more than ever, the gift of partnering in our collective contemplation of the law, retrospectively and for the future, is most crucial as our nations and the world take on the challenges still ahead. Again, thank you, and God bless you all. Mabuhay.
Hello again, and now it is my turn to present the second speaker of this panel. And before I do so, as everyone is aware of right now, we are extremely late. So let's try to catch up a little bit so that we do not end this, so that you have the time to go to the airport and catch your flights. It's not like we have so let's try to be brief. Our second guest speaker is the Honorable Mario V. Lopez, Associate Justice of the Supreme Court of the Philippines. Justice Mario Lopez became Associate Justice of the Supreme Court on December 5th, 2019. His illustrious career began when he pursued Bachelor of Laws in San Beda College, where he graduated with cum laude honors. Throughout his study, Justice Lopez was noted for his remarkable proficiency and was one of the celebrated top 30 in the 1980 bar examinations. His involvement in the judiciary started after law school as technical assistant in the Supreme Court, before working as hearing officer in the supervision and examination sector, Central Bank of the Philippines, and he served in the government as special prosecution officer with the Office of the Ombudsman until his appointment as RTC Judge of Batangas City in 1994. His legal acumen was immediately recognized. In 2005, he was honored with the Chief Justice Ramon Avancenia Award as Outstanding RTC Judge of the Philippines and for the best decision in a civil case in second-level courts. He is a recipient of the prestigious Service Award of the Province of La Union in 2013. Since then, the distinguished justice has been an active participant in the continuing development of the legal education. He is a professor of San Beda College, University of the Philippines, University of Asia and the Pacific, and Arellano University, where he was named the most outstanding professor of the year in 2002 and 2004. He is also a notable pre-bar reviewer handling criminal law in various schools. He is an MCLE lecturer and has conducted lectures in various institutions and IBP San Francisco, California, USA chapter. In April 2015, he was a guest lecturer at the University of California in Berkeley, California, in the United States. He is currently a professorial lecturer at the Philippine Judicial Academy of the Supreme Court of the Philippines. Justice Lopez is a state party governmental expert in criminal law of the UN Convention Against Corruption, a member of the Society for Judicial Excellence, Asian Law Association, an alumnus of the Harvard Law School, Massachusetts, and a fellow of the Academy of American and International Law, Plano, Texas, in the US. He is also a member of the 2014 Code of Crimes Committee and the Bar Exams Expert Committee at the University of the Philippines. He was the examiner in criminal law for the 2009 bar examination and the legal ethics for the 2017 bar examination. Before his appointment to the Supreme Court, Justice Lopez served as Associate Justice of the Court of Appeals for 13 years. He was the chairperson of the 12th Division and the chairperson of the Court of Appeals Rules Committee. You have the floor. Thank you.
Thank you, Professor Margarida. I am afraid I will be going very fast because I was already cautioned that I only have 10 minutes or 15 minutes. So anyway, I will try to be very brief as Vice Dean Margarida has said. My topic actually involves modernization of criminal laws in the Philippines towards universality and technology. This was prompted, of course, by the development in technology and our commitment internationally, obligations in the international law regarding the extension of territorial jurisdiction. And we are not bound strictly by the territoriality principle of criminal law. Okay, I will just give just a few mention about the colonization with Spain, because our criminal law is predominantly of Spanish origin. Of course, we all know that we were a colony of Spain, courtesy of a Portuguese explorer, Mr. Ferdinand Magellan, or locally known as Fernão de Magalhães. Okay. And during the Spanish regime, there were several laws that were implemented or effected in the Philippines, 1, 2, 3, 4, 5, 6, 7, but 6 and 7 are the ones which are related. But actually, I would not even say related. The prime criminal law of the Philippines. Why? Because this Spanish Penal Code enacted in 1870 and took effect in 1887 was simply translated into English. And hoopla, we have the revised Penal Code of the Philippines. It took effect in 1931. 1930 was the enactment, took effect January 1, 1931, and that revised penal code is still effective until the present day. 1930, today is 2022, add more 8 years, and we have a century-old penal code. As I have said, the revised penal code is the basic law that we apply in the Philippines. But this, of course, has been amended several times, repealed, and special laws were added. Okay, that is the revised penal code, Book 1 and Book 2. Construction, still we go back to the original text in cases of doubt in the interpretation of the penal statute. And then we still maintain the distinction of a mala prohibita and mala in se, regardless whether it is the revised penal code or the special laws. Now, this is the gist of my presentation. Recent developments in Philippine criminal law modernization and universal jurisdiction. What is universal jurisdiction? It is the enforcement of a penal statute regardless of the place, regardless of the person involved. But before going on, let me just go on very briefly the contents of these recent developments. Number one, I hope I can discuss each of one of these. Number one is the suspension of death penalty, imposition of community service, digital space and cybercrime, gender-related crimes, youth justice, dangerous drugs, anti-terrorism, and finally, I will be discussing Republic Act 9851 involving crimes against humanity. I hope I can discuss, but I will be very brief, as I have said, for all of this. This is broad, but don't worry, I can take care of it. All right, the first one, of course, suspension of death penalty. Now, the Philippines has prohibited death penalty. But while it has prohibited death penalty, it will still exist because the Constitution has not been amended and it merely prohibited. It may at any time be reenacted again, the imposition of death penalty. Of course, our commitment as regards this imposition of death penalty and the prohibition is in accordance with our observance of the Convention Against Torture, etc., cut of the ICCPR. Community service, well, that is in accordance with our rehabilitative purpose of criminal law under the principle of the positivist theory of penal statute. Then, a while ago, Justice Kagiwa mentioned about this people versus Hugueta regarding the valuation. In criminal law, we also have this adjustment of imposable fines and in accordance with the inflation rate based upon the imposable fines, value of the property, and value of damage. Okay. Now, I will go on. As I have said very quickly, I will just mention that technology, everyone is concerned with technology. In the Philippines, despite the pandemic, we have enhanced technology not only in civil law, we have also enhanced technology insofar as criminal prosecution is concerned. The very basic law that was passed in the enforcement of the crimes involving the digital space and cybercrime is Republic Act 10175, or the so-called Cybercrime Protection Act of 2012. The Philippines' compliance with the Budapest Convention on Cybercrime of the Council of Europe prompted us to enact this Cybercrime Prevention Act of 2012. This is comprehensive. This is the basic law, as I have said, that deals with cybercrime, with cybercrimes. In fact, the Council of Europe recognized the Cybercrime Prevention Act as a full implementation of the Budapest Convention and as a sound cybercrime legislation. Because of the broadness of the use of computer, we have Section 6 of the Act, which provides a penalty 1 degree higher whenever the use of a computer is done, or the computer is used for purposes of committing any crime for that matter, whether under the revised penal code or under special law, the penalty is 1 degree higher. And then what are those crimes that are covered by this Cybercrime Act? Offenses against the confidentiality, integrity, and availability of computer data, such as illegal access, data interference, misuse of devices, cyber squatting, among others. What are these computer-related offenses which are penalized? Computer-related forgery, fraud, computer-related identity theft, and of course, we have these content-related offenses like child pornography, libel, and even cyber sex. Now, in terms of jurisdiction, we have implemented the law, not only within the bound of our territory, but rather it involves a Filipino, regardless of the place of commission. The offender is a Filipino, the victim is a Filipino, the court, the Philippine court, can take cognizance of. Take note, letter D, when the commission of the crime caused damage to a natural or even a juridical person who at the time of the offense was committed was in the Philippines, the court of the Philippines can take cognizance of this particular crime. Gender-related crimes. Initially, we have Republic Act number 7877 of 1995, but this was a limited criminal prosecution that involves sexual harassment in a work-related or employment environment and in an education or training environment. It did not address the issue of sexual harassment among peers or co-employees or those against a superior. Thus, we have enacted a broader one, which is Safe Spaces Act, enacted in 2019, Republic Act 11313, and it covers all forms of gender-based sexual harassment committed in public spaces, educational or training institution, workplace, as well as online space. Notice that the place public spaces will now include online spaces or the cyber space. In fact, gender-based online sexual harassment is specifically penalized under this code or under this special law. Sorry, I have to go very fast, as I have said. Then we have the anti-violence against women and their children. This was triggered by our compliance with the Convention on the Elimination of All Forms of Discrimination Against Women, or the so-called CEDAW. And sorry, folks, sorry to all gentlemen, LGBTQAI plus can be the offender under this law, but only women and their children can be the victim. Male spouses, male boyfriends, sorry folks, you cannot be the victim in our violence against women and children. Insofar as violence is concerned, it is not limited to physical violence. It includes sexual, psychological, or even economic violence. Again, extraterritorial application, we extend the jurisdiction in the enforcement of this law, such that a violation of BAUSI, or Violence Against Women Act, is considered as a transitory offense. We know what is a transitory offense. Whenever the elements of the crime occur in one place or in another place, regardless, as long as the essential ingredients or elements of the crime happens within the jurisdiction of the court, we can try the case. For instance, in one case, the offender is in the United States, but the victim is in the Philippines. The court has convicted the accused. Youth justice. A while ago, it was also mentioned again, our commitment to the United Nations Convention on the Rights of the Child and our commitment to the international community. Notice the definition of a child and the Republic Act 9344 or 2006. Notice, a child 15 years old has or is the person who become liable, and that is the minimum age of criminal responsibility. Above 15, but below 18 years, the offender must act with discernment. Otherwise, he may be exempt. But for purposes of the child's welfare, the court may allow the child to undergo an intervention, the diversion program, raising the age of sexual consent. You are aware of the so-called statutory rape, so that if a woman is engaged in sexual intercourse with or without consent, consensual, it does not matter. It is a rape if the victim is below 12 years old. Now, under Republic Act 11648, we have raised that statutory age to 16 years old. Anti-Child Pornography Act of 2009. This is one of the special laws enacted in accordance with that Cybercrime Act. And again, this is in compliance with the Convention on the Rights of Child, elimination of the worst form of child labor, and the Convention Against Transnational Organized Crime. Under this law, the production, publication, possession with intent, and willful access of any form of child pornography is punishable. This is significant. Why? Because our definition of a child involved 18 or below children, but even if they are above 18, if that child cannot protect himself or herself from abuse, neglect, cruelty, or exploitation, or has physical or mental disability, even if he is above 18, that person can still be considered as a child subject to this Anti-Pornography Act of 2009. And notice also that liability is not limited to the person or persons who actually committed the specific acts. It includes internet service providers and internet content hosts. They are punishable. dangerous drugs law. Nobody is spared from this problem. The whole world has this problem. In fact, even in the year 1800s, when the old penal code was effected in the Philippines, and until it was revised, it is still embodied in that revised penal code. And this Republic Act 6425, that is the law which amended the penal code, the revised penal code, involving violations of drugs acts. And this was not enough for the Philippines. It was followed by another law, which is now the Republic Act 9165, and was further amended by Republic Act 10640. And one of the significant changes involved is one of the significant changes introduced by Republic Act 9165/2002 is the drug trading with the use of internet. So that even if there are no drugs, if it can be proven that there is a dealing, negotiation involving drugs, the same can be the subject of prosecution in the Philippine courts. And lastly, considering the matter of substitution and alteration of drugs, we have enacted in Republic Act 9165 the so-called chain of custody. This is a manner or mode of authenticating that the drugs that was seized from the accused is the same drug that is presented before the court. Of course, you are aware that it is very easy. It is very easy for the police officers to or even so evidence against we see to it that this at least be avoided, if not totally eliminated, by this chain of custody rule, whereas I have said, from the time the drug is seized, turned over to the investigating officer, to the forensic chemist, until the presentation of the court, a clear evidence that the integrity is preserved, meaning the drug that was seized is the same drug that was presented in court. Anti-terrorism, again, another law which confronts every one of us. Originally, we have Human Security Act of 2007, but this law was very restrictive. In fact, nobody was convicted because of the presence of a predicate crime. It has the characteristic of a widespread and ordinary fear and panic among the populace. And the purpose is to coerce the government to give in to an unlawful demand. Very restrictive, that nobody was convicted under this law. Hence, in 2020, the Anti-Terrorism Act was enacted, and in this law, inchoate crimes involving anti-terrorism is already made punishable. Of course, this is understandable because we have to nip the bud whenever there is already a crime that is being planned for purposes of terrorism. We have to stop that offense. Otherwise, it may be too late for us. Hence, threat to commit, planning, training, facilitating, proposal, inciting are all defined as a crime under the new Terrorism Act. Additionally, that predicate crimes is already removed. The basic model of legislation which was embodied in Section 4 as provided in the United Nations Security Resolution 1624, called upon the states to adopt measures to punish and prevent terrorism. And hence, we have this basic formula of what terrorism is, consisting of actus reus, mens rea, and the purpose and context. Notice, the actus rea is broad actus reus. Acts which cause injury or damage to any person, infrastructure, or government. It is no longer limited only to the government, but any person or infrastructure. And the mens rea is to intimidate the public or destabilization of the political, economic, and social order of the country. Unlike the old one, it is purely political in nature. Now, this terrorism act of 2020 is broader in character. Then, to protect also the state, detention without judicial warrants of arrest was extended from 14 days and extendable to another 10 days. This one is quite significant. Extraterritoriality principle in the application of the Terrorism Act of 2020. Why? Because Filipino citizens or national, of course, we know that there is a difference between a citizen and a national. So that regardless whether the offender is a Filipino citizen or a national, the court can take jurisdiction. And then the usual territorial limits, Philippine ship or Philippine airship, embassy, consulate, these are the usual ones. But I take particular significance as regards number 6. Although physically outside the territorial limits of the Philippines, commit said crimes directly against the Philippine government. As long as the government of the Philippines is the victim, regardless where the offender is, we can try the offense of terrorism. And finally, Madam Vice Dean, finally, I hope I did not go beyond 10 minutes. Crime against international humanitarian law, genocide, and other crimes against humanity. This was enacted in adherence to Hague Conventions of 1907 and the Geneva Conventions on the Protection of Victims of War and international humanitarian law. What are those offenses punishable? War crimes, genocides, and other crimes against humanity. These are organized crimes. Although in 2018, the Philippines had withdrawn from the membership in the Rome Statute of International Criminal Court, the Philippines still and maintains the effectivity of this law for purposes of domestic prosecution of crimes against humanity. And what is the jurisdiction of the Philippine court as regards this crime? The jurisdiction is universal. Regardless, of course, Filipino citizen against a Filipino citizen, but notice, regardless of citizenship or residence, regardless where the crime is committed, as long as that offender is present in the Philippines, he could be apprehended and prosecuted. Any offender, you can run, but you cannot hide in our country because you can be prosecuted. In conclusion, allow me to quote. In view of the growing number and technological complexities of criminal offenses, both in the domestic and international fora, the Philippines has endeavored to enhance its criminal justice system consistent with its political, social, economic, moral, and cultural environment. Notably, the Philippine Congress has enacted several statutes in deference to the Philippines' commitment to the international community while balancing the constitutional rights of the accused and states' right to self-preservation. Obrigado. Thank you very much.
Thank you very much. And now I will introduce the third and last speaker of our panel, Professor Jose Manuel Torres Perea of the University of Malaga. Graduated in 1989 from ICADE, Specialty E1, Madrid, Spain. In 1992-94, he attended the doctorate program at University of Malaga, where he has been teaching since 1995. He obtained his PhD degree in 1999. Since January 2002, he has been assistant professor of civil law at the University of Malaga. Thanks to the skills acquired during his training period, he has been able to make important contributions in the field of research throughout his career. He has participated in 9 competitive research projects and has, to his credit, more than 50 scientific publications with 3 active sexennial research evaluations by ANECA. Another way of disseminating his research activity is the presentation of numerous communications and papers in scientific congresses and conferences, both national and international. He has been visiting professor at Goethe Universität, Frankfurt, Regensburg Universität, Regensburg Northwestern University, Chicago, and University of Pennsylvania, Philadelphia, among others. He is currently the coordinator of the Erasmus Plus K2 capacity building for legal and social advancement in the Philippines, CALESA. This project is led by the University of Malaga and involves the Nova University of Lisbon, Deusto, University College of Dublin, University of the Philippines, University Ateneo of Manila, University St. Agustin, Iloilo Ateneo de Zamboanga University, and the Philippine Judicial Academy belonging to the Supreme Court of the Philippines. Professor Jose Manuel Torres Perea, you have the floor. Thank you very much.
Thank you. Thank you very much. I am informed by the organization that I have minus 10 minutes to speak or shorten. So I must shorten what I have prepared, but I would like at least to give you information about the essential, about what I want. It's a very personal approach. We are now we're speaking about university, academic teaching, and now the higher education institutions are in a ideological, technological, and generational crossroads. And this crossroad is due to, I am very fast, so sorry, but I must. 5 factors. These 5 factors are, first, the impact of new technologies. And when I refer the impact of new technologies, I don't refer to the new tools, the new softwares, but also the brain of our new generation students, because it's formed by these new technologies. Second, of course, the first confinement. The COVID-19, this pandemic, is an inflation point. The millennial generation, we have a millennial generation, we can call the Z generation whenever we want, that is absolutely different to the former ones, because when they have been born, they have been educated by electronic tools. I refer that when I was a child, I play in a way close that a child of a Roman could play 2,000 years ago, and totally different from the way that a child now of 5 years can play with the tablet, etc. Change in values. Change in values is totally important and essential because the values in our society are changing. When the values change, everything is changing and the university is totally affected. And finally, the phenomena of globalization. The phenomena of globalization is something that is affecting every university in every corner of the world, and is affecting the way of learning, the way to access to the information. What is the challenge of the university today? We have to go from what I call an analogic culture, or maybe pre-digital culture, to a digital one. From the Bologna process, we have tried to do it through, first, the change of curricula. Second, introducing a very principle. Learning is a lifelong task. Third, organizing a schedule. Now the professor have to plan the work of the students. How many hours is going to work at home in order to prepare the class? And then the dean office has to organize all the information of all the professors to know if what they are offering to the students is reasonable or not. And of course, the introduction of new technologies. All this is creating a new type of professor who see how the teaching workload has multiplied exponentially. In Spain, we have one organization, it's called ANECA, is the organization from the ministry that take care of the quality of the research, that is establishing more and more demanding requirements to be fulfilled by the professors. Finally, I can say that we are starting to see in the university professors that are under the burnout syndrome. That was something for primary, secondary, but now is so enormous the load of work that this is happening. In addition, the professor has to fulfill the expectation of the students and to fulfill the expectation of a millennial generation that is critical by nature, that they are living in what is called a liquid society, with the problem that implies to live in that liquid principal society. And that is the word flood for thousands of stimuli and bytes of information. What is the problem for the new generation? They are the ones who have most tools in order to improve their training. But the problem is they have no criteria to distinguish between what information is the right one and what information is the wrong one. And in this point, the experience of the former non-digital generation is very helpful for this one, because from this perspective, they can get access to the criteria to distinguish. We have to take into account something. During the pandemic, the evolution of technology in the university have evolved more in 2 years than what this evolution would have had in 1 decade or 2 decades without pandemic. Now, sorry, I forgot. This is the 5. Now, risk factors. When I refer to risk factors, I love to speak about Toffer. Toffer in the year 1995, far away, he thought the following: the university change when is the combination of 3 determining change circumstances. First, significant external pressure. Significant external pressure from the market, from the globalization. You can take into account a university, a local university that 20 years ago had not any influence from any other place, any competence. Today online, of course, there is a lot of competence that can suffer. Coherent alternatives. Coherent alternatives is a problem for us. Well, it's not a problem. It's a challenge before. Because now we have big companies like Microsoft, like Google, that offer capacitation course for students that could be more attractive than even a course by Howard for our students. If we consider in the possibility to work in these big companies, of course. And finally, the dissatisfaction of the personnel involved. I would like to deep in this point. We have what we call a student the motivation when the student consider that the university is not linked to the market, is not linked to the society. If the student consider that to study is not a way to get a job, a good job, a job with dignity, he's totally demotivated. Second, the students are demotivated when they consider that in the university there are opacity and endogamy. We have a new problem with this millennial generation because they don't understand sometimes that the way of teaching is theoretical And the way of evaluation is memoristic. And why? Because if we attend the teaching in primary and secondary are not memoristic, no anymore. It's considered to learn by experience. And if we consider the way they have formed their brain using electronic tools in the cyberspace, they have learning by experience, by trying, try, and finally they get, and then they have a learning. So for them, this memoristic way of learning by heart is not natural. I don't say that this is good or bad. I say what is the thinking of our students now. Finally, we are in a war in continuous crisis scenario, what is negative, and we have what is called by the professor of Howard, Sandals, that is the problem of the meritocracy expectations, because sometimes we are looking for a professional track in which we explore ourselves and we don't need the help of an external pressure to exploit ourselves. So when we achieve one task, then we impose ourselves another task, both students and scholars. So the next doesn't the motivation. Well, we have the problem. The problem is that there is a continuous and demanding evaluation system of our teaching staff, not only in teaching, but in research and management. In addition, now the system to evaluate the students is continuous evaluation. 20 years ago, there was only one final examination. Now is every week one examination. We think that sometimes we have a group of 120 students and we have to evaluate every week, all of them, we have a problem. And as Marilu said the other day, to think that the evaluation is only by internet, that only with a multiple choice test they are learning law is totally wrong. We need reflection, and this is by writing, in order to have a right evaluation. We have then the impossibility of sharing teaching and research. But the teacher in Europe must research. So we are in a dilemma. The duty of the teacher to achieve excellence of the students, all these go to what I called you before, the burnout syndrome, that the teacher wants to have a professional track that impose to establish one, to exploit himself by tasks that when he achieve are new tasks, and that is what if we see the Korean philosopher Byung-Chul Han, that is popular now, he said that is the way the neoliberalism is making an efficient system to explore the freedom of the society. All this goes to what is called the VUCA factors: volatility, because nothing is permanent; uncertainty, because we have no criteria to distinguish when there is a flood of information; complexity, because all this information makes complex everything; and ambiguity, because if we have no criteria, we have unambiguous. What are the students demanding from the university today? They are demanding to develop capabilities for continuous adaptation to change, to become learners with the capacity of immediate response. All these go to the new roles that we see in the university. The first, learning is a lifelong task. Second, the teacher role is not longer to be a repository of information. The teacher has to be a guide in the training of the students. The teacher or the professor must encourage the student what is called to the team learning and to the cyberspace learning. But I read about always, I read that in the class must be a shared responsibility shared by professor and students, and that the expectation of the student is to feel as a protagonist in the class. In addition, we have the implementation of the ICTs, information, communication, technology tools, access to big data, and we have very important software tools that are really very good for our teaching. I am referring, for example, to the Canva, the Moodle platform we are all using in the university, but also the Kanban board. The Kanban board is very useful for a project in which you can put all the information of the project to know what to do, what is in progress, what is done, and putting together with all the information of the project. The Kanban most popular tool is Trello, I think. And in the CALESA project, we use the Airtable as a way. This implies some limitations, and the limitations that the new technology implies are, first, the motivational effect of the face-to-face teaching. If we, from the neuro-linguistic approach, they inform us that the full communication is visual communication. We can only communicate with our students when we are looking at eyes and we are reading the eyes. We know they are understand or not. The body language is very important. If we only use a screen and if we have an online class, we are only using one of the 5 senses we have. The shortcoming of the online evaluation, that we have had online evaluation in the pandemic, we know that we have a lot of problems. First, for the identification of the student. You can have some prevention when it's a final examination, but if you examine it every week, it's very difficult to know who is answering the questions. And sometimes it's very difficult to know if they are not using Viber altogether in order to do a collective answer. Shortcoming in the text system. When we refer to the multiple choice test, in my humble point of view, that is not a way of teaching law or evaluating law. For evaluating law, we need reflection. We need that the student write a sentence explaining why yes or why not the solution, the application of this article, not only a test. And finally, the important is to have criteria, and to have criteria is necessary a minimum knowledge, and the minimum knowledge require memorization. We cannot pretend, because what we are doing here is not to changing the content of law when we are teaching law now. The content is the same. The only one we are going to do is perhaps to change the way we are teaching. But always there is a minimum that must be based on what we call that is the background that is memorized by the students. Well, I have prepared a lot of more slides, but we are very short of time. I summarize everything. What are the solutions? Because we say the situation is critical because we have to adapt the university to a new generation that is totally adapted to the new technologies, but we not. And I think that in addition, we are in a society where there is relativism. And in order to fight against relativism, I think that the first is to have principles, to teach our students through principles. And in this point, I think that the best is to take into account Ronald Dworkin when he refers to the modern use naturalism, and to forget Herbert Hart when he speaks about positivism. We need to provide, for example, if we think in the judge, principles in order that the judge can choose between 2 contradictory rules. We cannot pretend that the function of the judge is only to apply one rule. We can apply this to the teaching to our students. And finally, what is the real problem of our students? Again, the hyperactivity that is created by receiving thousands and thousands of stimuli, thousands of information without the possibility to have any time for forming a criteria. So the antidote, the solution is to learn to pay attention. The solution is to have a reflection, to learn to have reflection, to stop hyperactivity. And if we follow this philosopher, Byung-Chul Han, he said that we must to introduce in our students the concern that they must educate their mind. Educate their mind implies long contemplation, even ascetic in the words of this philosopher, even meditation, because we have to create a scenario in which they are protected of being the whole day affected by thousands of informations that don't allow them to know what they are doing. So that is will be. And finally, remember, the priority of teaching is to get the personal growth of our students. That is the only priority we have had. So sorry, I have to shorten 20 slides, but is what I can do. Thank you very much.
Thank you.
Thank you very much. There will be no Q&A session. We are now taking a final group photo, and then we move to the break.
Thank you very much to the moderator and panelists, which we invite to remain on stage for the photo. This closes our first session of the morning. We now invite you all to the coffee break. We ask you to just go pick something, a coffee or some biscuits, and to come back, please. And we kindly ask you to join the upcoming parallel panel sessions to the conference. Panel number 3 will be held here, and panel number 4 will be held at the Nova School of Law. Please refer to your program for further information and ask our volunteers if you need directions. But where is But I don't see this one. And he can unmute himself. Yeah. Okay, perfect. We're just checking. Yes. No, I just shortened it. Exactly. Or I just mentioned names. Yes. And, okay, let me just run a test whether we have also Dean Jose Maria Tirol with us. If you can hear us and you can unmute yourself.
Hi, I'm here. I'm here.
We cannot see you, Guillermo. The camera is off, but as you can,
Yeah, I'm here. Hi.
I don't know. And you can see me as well. Okay, hi.
Hello. Hi. Can I share my screen later?
We cannot hear properly.
Can I share my screen later?
Yes, absolutely.
Oh, okay.
So
Thank you. Thank you.
Or as second speaker, I apologize in advance. I'll be strict with time. So is it okay to have a 10-minute slot for you to cover all your presentation?
Yes, yes, yes.
Yes. Okay. So I'll just keep an eye on the time, and I'll hand to you the floor after Chancellor Karadang.
Thank you.
Okay. No, thanks to you, and apologies again for the delay.
Consegui reduzir o passo do bar, para tentar terminar de distrito. Já tempo de marcar
Moving forward to our next section, we welcome to the stage Professor Julia Priora, who will moderate the first panel on resilience in R&D during COVID-19 pandemics. Professor Julia Priora is assistant professor in private law at the Nova School of Law, where she teaches intellectual property, platforms regulation, and legal research methodologies. A prolific author on the topics of digital access to education and information, and an expert on comparative and European intellectual property law. Professor Priora recently focused her research on the legal implications of the digital university spaces and the interplay between IP law and sustainability. We would like to take the photo of the panel now. Let's see only if we
We are
find the...
waiting, yes, with Professor Claire to sit also with us. I think the photo can be taken while we are already presenting the speakers, and after the panel, we can have also the certificates. Thank you so much. Thanks also Sophia and the organizers for putting this together, but thanks in particular to our distinguished speaker. It's my honor to hand over the floor straight away to our first speaker, who's Chancellor Rosemary De Claro Caradine. So very briefly, and I apologize for summing up the bios, now retired Supreme Court Associate Justice Rosemary De Claro Caradine was appointed as Chancellor of the Philippine Judicial Academy recently in February. And we have with us a talented jurist and scholar. She's an alumni of the University of the Philippines and an outstanding legal professional. I just wanted to very briefly mention that as appointed Associate Justice of the Supreme Court, Justin Kerrigan penned the High Court December 7, 2021 landmark decision on Anti-Terrorism Act of 2020. I really apologize for not sharing more information, but the distinguished speaker, I think, deserve the little time we have at disposal in this wonderful conference. So, Chancellor, the floor is yours. Thank you.
Good morning, everyone. I will forego with the salutations because of time constraints. One water, please. The Philippine Judicial Academy was first established in 1996 by administrative creation of the Philippine Supreme Court in cognizance of its constitutional mandate that members of the judiciary must be of proven competence, integrity, probity, independence, and acting upon a keen recognition of the vital role of the judicial education to a competent and efficient judiciary. The Academy, also better known as PhilJA, was charged with formulating and implementing a continuing program of judicial educations for justices, judges, court personnel, and lawyers. In 1998, or 2 years later, Congress granted statutory recognition to PhilJA and passed its legislative charter, Republic Act number 8557, declaring it a policy of the state to ensure an efficient and credible judiciary and institutionalizing PhilJA as a training school for judges, justices, court personnel, lawyers, and aspirants to judicial posts. As a separate but component unit of the Supreme Court of the Philippines, PhilJA operates under the former's administrative supervision and control. Funding for PhilJA's operation, maintenance, and improvement forms part of the annual budgetary allocation of the Philippine Supreme Court. The Board of Trustees is the governing body charged to formulate and approve all policy proposals to keep with the general trust of the Academy. It is chaired by the Chief Justice of the Supreme Court of the Philippines, with Senior Associate Justice sitting as its Vice Chair. Its members are the PhilJA Chancellor, the presiding justices of the Court of Appeals, Sandigang Bayan, and Court of Tax Appeals, the Court Administrator, the President of the Philippine Judges Association, the President of the Philippine Association of Law Schools, and a representative from the first level court appointed by the Board of Trustees. PhilJA's goal is to ensure that the judiciary is composed of men and women with proven competence, integrity, probity, independence, and the task is to provide and implement a curriculum for judicial education and to conduct seminars, workshops, and other training programs designed to upgrade their legal knowledge, moral fitness, probity, efficiency, and capability. As it stands, the Philippine judiciary is structured in this manner. At the helm is the Supreme Court, currently headed by Chief Justice Alexander G. Hesmundo, where he is joined by 14 associate justices. On the appellate level, 19 justices comprise the Court of Appeals, the Anti-Graft Court known as the Sandigang Bayan, and the Court of Tax Appeals. At the forefront of the Philippine judicial system, where more than 2,000 sitting judges are stationed nationwide, are the first level courts, more commonly referred to as the Metropolitan Trial Courts, municipal trial courts in cities, municipal trial courts, and municipal circuit trial courts. And the second level courts are known as the regional trial courts. The Sharia circuit courts, the counterpart of the municipal circuit trial courts, are established in certain municipalities in Mindanao. Equivalent to the regional trial courts in rank are the Sharia district courts, established in certain provinces in Mindanao. These are the two courts of limited jurisdiction which govern and enforce the Code of Muslim Personal Laws of the Philippines. Court personnel holding various roles and positions, all requiring regular programs of judicial training, numbered to more than 23,000 nationwide. In accomplishing its enormous task as the sole training arm of the Supreme Court for the entire judiciary, PhilJA relies heavily on the dedication of its pool of educators. We call them a corps of professional lecturers composed of retired and incumbent justices, judges, learned academicians, and esteemed law practitioners. The PhilJA Academic Council, which is composed of chairpersons of various curricular departments, considers, develops, and approves training programs and activities, and set out policies for these programs. PhilJA benefits from a strong partnership with other educational and training institutions and enters into consortium agreements for the development and implementation of program for orientation, career development, and continuing judicial education. Our long-standing programs done in collaboration with local and international development agencies, such as the American Bar Association Rule of Law Initiative, or ABAROLI, the Asian Development Bank, the European Commission, the International Development Law Organization, the International Organization for Judicial Training, the Asia Foundation, the United Agency for International Development, and the United States Department of Justice Criminal Division, Office of Overseas Prosecutorial Development, Assistance, and Training. They have underscored the direct relationship between a credible, competent judiciary and efficacious judicial education. In the formulation of each judicial education program, PhilJA adheres to the philosophy that people are best served when the judiciary is independent and its members are women and men of proven competence, integrity, probity, and independence. In the enhancement of each judicial programs, PhilJA considers the following core areas: judicial person, which deals with the values, attitudes, behavior, as well as outlook of a member of the bench. Judicial skills, which introduces the judges to management and administrative skills, as well as research, communication, and decision-writing skills that the judicial office demands. And judicial knowledge, which engages the participants in a more intensive study of substantive and procedural law from a judicial perspective. While PhilJA adopts an encompassing and holistic approach to judicial education, providing a continuing program of orientation and enhancement training to address not only the needs of judges, but also that of the whole court complement. At the core of its training program is the judicial education of judges and its flagship program, the Pre-Judicature Program, or PJP. The Pre-Judicature Program, or PJP, was conceptualized to fulfill the mandate of the Academy under its legislative charter, which is to screen appointments to judicial posts, whether original or for promotion, to ensure that the constitutional requirements of competence, integrity, probity, and independence are satisfied. And that is enshrined in our Section 7C, Article 8 of the 1987 Constitution, Section 10, Republic Act number 8557. As a matter of policy and practice, even where the PJP was not a prerequisite to applications for judgeships before, PhilJA furnishes the names of participants who completed the PJP to the Philippine Judicial and Bar Council, a constitutionally created body which evaluates applicants for appointment to judicial posts and submits a short list of nominees to the President of the Philippines, who appoints the judges from top to bottom, from the highest to the lowest rank. It is from this short list of nominees that the President of the Republic of the Philippines chooses and appoints the members of the judiciary. The first PJP delivered was in June 2000, and up until its fifth reiteration in 2003, it had been delivered in two phases. This was integrated into a singular program in the sixth run. Also, for the seventh PJP, until the 51st participation was deemed compliance with the mandatory continuing legal education requirements for lawyers in the Philippines. Hence, during that period, the PJP did not exclusively cater to applicants for judicial posts. Many enrolled simply to earn credits for continuing education and not really to apply for judgeship. While the PJP should really be a selection or qualifying process, its early character did not gear much on assessment but on training. In fact, its initial design was for the orientation and guidance of aspirants towards a career in the judiciary. It offered a judicial perspective on the law and introduced skills, attitudes, values, and appropriate conduct called for by appointment to the bench. The sessions were not really a repeat instructions of law school subjects, but were still heavy on knowledge, although aimed at providing for a more reflective, concept-based philosophical approach to the subjects. The original PJP ran 51 times since its inception, but no matter how admirable its beginning was, it certainly had miles to go in achieving its full function as a screening tool. The PJP need to evolve from a purely training activity into assessment program, and from an exercise of desirable value to a requirement that is mandatory. This change would fully align it to the legislative intent that only participants who have completed the programs prescribed by the Academy and has satisfactorily complied with all the requirements incident thereto may be promoted or appointed to any position or vacancy in the judiciary. The 51st PJP in November 2019 was the last training type program conducted before the pandemic struck. When it seemed like the world health crisis had put an abrupt end to PhilJA's activities and dampened its work on revising its training program, a significant shift in the PJP was concretized and carried out in the middle of the pandemic. The vision of a judiciary that is independent, competent, effective, and enjoys public trust and confidence guided PhilJA to a clear and meaningful direction, even in the face of challenging times. It was during the pandemic that PhilJA immediately took the prodigious task of overhauling the manner of delivering the PJP. PhilJA did not satisfy itself with merely converting its previous PJP to an online setup with lecturers teaching in front of a video camera. More than just accepting that pandemic was here to stay, PhilJA took this adversity as an opportunity to revamp and revise the program and its curriculum. Thus, PhilJA relentlessly sought ways to deliver a shorter, hybrid, blended program that would accommodate a greater number of participants without compromising the quality of assessments made. On September 2021, PhilJA launched the new Prejudicature program, a pre-judgeship or higher judgeship course and an assessment process to determine the suitability of participants for judicial posts. In the new PJP, participants are evaluated based on knowledge, skills, and ethics values. Aside from providing information, participants are tested for aptitude in the application of such information, in their capacity for logical analysis, faculty communication, both oral and written, management ability, and competence, integrity, probity, and independence. The new approach to the PJP is outcome-based education that is performance-oriented and competency-based. It employs adult education techniques and uses blended learning methodology, combining the self-paced technique of asynchronous learning and the real-time interactive sessions of synchronous learning. The new PJP is required of all aspiring to judicial posts, whether in the first and second level, including the shariah courts or the appellate courts. It has a comprehensive individual assessment and employs a rubric scoring guide in evaluating performance rating. The numerical and descriptive performance ratings provided by PhilJA gives a full assessment report on the level of competence of PJP participants aspiring for a judicial post or promotion. PhilJA rolls out two types of pre-judicature programs: the PJP for trial courts, or what we simply call PJP, or the PJP for appellate courts, or PJPA. While the PJP assessed the participants' suitability for the judicial posts, the participants in the PJPA are additionally assessed on their skills to adjudicate and efficiently resolve cases on appeal, their ability to render appropriate rulings on hypothetical cases, and whether they have the requisite judicial attitude, temperament, and adaptability to work in a collegial setup. The demand for PJP for trial courts is significantly greater than the demand for PJPAs, given the judicial vacancies in the first and second level courts. I am proud to declare that since 2020, the Academy has increased the number of PJPs delivered per year by 86%. Despite this success, PhilJA incessantly reevaluates its course content and program delivery to further improve this percentage. At present, the Academy is studying the feasibility of delivering 140% more PJPs since the start of the pandemic. After their appointment and before performing their judicial functions, judges must undertake an orientation seminar workshop conducted also by PhilJA. From a juridical perspective, judges are engaged in a more intense study of substantive and procedural law. They are likewise introduced to management and administrative skills, as well as research, communication, decision writing skills, and that their office demands. This approach is necessary due to the dual nature of their judicial functions. Aside from adjudicating cases, judges are also expected to manage their own respective courts. Included in this preparatory program is the development of their values, attitudes, behavior, and mindset as members of the bench. Moving forward, Aristotle said, to go to a judge is to go to justice. For the ideal judge is, so to speak, justice personified. Judges are a visible representation of the law and justice. Our mandate is to give them the proper judicial education and training to help reduce docket congestion and case delay. Timely and effective adjudication coupled with the elimination of unreasonable delay in the resolution of cases will help regain or maintain, as the case may be, the public trust and confidence in our judiciary. The Supreme Court of the Philippines recently released its policy document entitled Justice Real Time, a Strategic Plan for Judicial Innovations 2022 to 2027. Under the Judiciary's Action Blueprint, PhilJA is directed to undertake a curriculum review of its core and special programs to shift completely to outcome-based education. This shift will create a needs to results equation as basis for the formulation and conduct of future programs. At present, PhilJA, including its policy-making body, the Academic Council, operates within the traditional structure of individual departments along the lines of law subjects rather than general competencies. It is significant to note that such divisions heavily rely on the divisions of the Philippine bar examinations. Such setup is reminiscent of how our law schools teach law students, designed to enable law students to hurdle the bar examination by testing their surface knowledge of the law. This setup, however, does not effectively educate our judges, whose professional needs are specialized, but fortunately predictable. In response to the directive to shift to the outcome-based education, PhilJA recently rolled out its enhanced PJP for trial courts. The pandemic taught PhilJA to leverage on technology and to be efficient. Participants still begin the program by studying asynchronously using pre-recorded materials, videos, supplemented by practical exercises. For the synchronous phase now conducted on a face-to-face setup, participants take part in activities which are designed to cross-cut issues, test their analytical skills, assess their writing proficiency. Presently, one of these activities is a three-part moot court case scenario, touching on all aspects of trial with its own issues, incidents, and problems. Subsequently, written exercises are given based on these three anchor cases. A first round exercise is conducted where more than 50 to 100 questions are asked to gauge the participants' ability to think quickly on their feet, dealing in substantive law and procedure. Finally, a post-program evaluative test is administered to ensure that the participants have fully integrated their comprehension of both asynchronous and synchronous session. The enhanced PJP promotes shared facilitation and responsibility between the academic departments while ensuring faster assessment of participants' performance. This bodes well for the immediate demand for more PJPs for trial courts in our jurisdiction, as there are many vacancies in the trial court level. The process of curriculum development is evolving, touching upon new developments in law, particularly in environmental protection, trafficking, gender-based education, anti-money laundering, terrorism, cybercrimes, financial crimes. PhilJA envisions a holistic approach, recognizing that the judge's knowledge, skills, and ethical values and attitudes must be continuously nurtured during their tenure. To accomplish this, the Academy has adopted a ladderized training system tailor-fit for the learning level of the individual. From pre-judgeship, which is covered by the PJP, to advances in her judicial career, which is handled by the Judiciary Career Enhancement Program. Currently, PhilJA has adopted the learning management system, which tracks the courses taken by the members of the judiciary. In the future, the LMS will make available courses appropriate for the individual judges. Some courts are handling special cases like commercial courts, family courts, and environmental courts. It will be programmed to avoid repeating content already delivered in prior levels and build on the programs already taken instead. The LMS is projected to create a blueprint for our judges' judicial education in order to aid them in mapping out their desired judicial career path, whether they seek to be knowledgeable in all legal topics or they prefer to carve out a special skill in a particular field of law, like family law, commercial law, environmental law, and so on and so forth. You can't improve what you can't measure. The outcome-based shift needs an objective assessment mechanism to measure program efficiency. Our Supreme Court mandates 3 tiers for this new assessment mechanism. The pre-program assessment analyzes the needs of the target trainees at least 3 months before the proposed program. The on-site program assessment is made immediately after each session of the program, and the post-program assessment evaluates the utility of the program from the perspective of the trainee, trainers, peers, and colleagues of the trainee and the court users. To live up to its name and fully function as an educational institution, PhilJA will establish, offer, and implement degree and certificate programs catering exclusively to judicial officials, staff, and personnel. Their continued learning will expectedly translate to improved quality of public service they render. This may be done through partnerships with learning institutions or by amending PhilJA's charter, which will allow it to undertake an ambitious program to confer a Master's of Laws degree. We also enhance the knowledge, skills, and capabilities not only of our judges, but also of our court employees, the judges' frontline partners in the timely dispensation of justice. Special modules are developed for each category of court personnel, like clerks, interpreters, stenographers, legal researchers, sheriffs, process servers, and others. We all know that COVID-19 is here to stay. Although science is finding ways to battle this virus, reality dictates that we must progress to avoid a regress. We all need to forward lest we allow ourselves to stagnate. Like the rest of the world, the PhilJA and the Philippine Supreme Court have accepted, if not embraced, this new normal. This is evident from the Philippine judiciary's trust of investing in information technology, infrastructure, and in training all personnel involved in all IT-related activities. For our part, PhilJA is constantly seeking ways to improve the performance of its duty. Last July, PhilJA partnered with the International Development Law Organization and held a training of trainers where PhilJA interactively polished its skills in conducting hybrid blended sessions. We do not aim for the bare minimum, meaning we teach not just to transfer knowledge. With the training of trainers, PhilJA sought to conduct seminar workshops that will increase participant engagement and comprehension. Indeed, out of adversity comes opportunity to innovate and to be better. Thank you and good morning to all.
Thank you very much. We move forward since the Chancellor will have also to leave as earlier before the end of the panel to Dean José Marie Tirol, who's with us connected via Zoom. So I just ask our Guillermo to showcase perfect. So we run a test and I think you are able to hear us, and please unmute yourself and
Yes,
the floor is yours.
yes, Professor, I can hear you. I can hear you. I hope you can hear me too.
Yes, we can hear you. I'm very conscious about time, so I ask you as
Yes.
telling you 10 minutes. I'll keep my eyes on the watch and inform you when 2 minutes are left. Thank you so much.
Okay, thank you. May I share my screen?
Yes, please.
Okay.
Thank you.
So Professor, do I start now?
Yes, we can see also the slides.
All right. So good evening to everyone. I am Jose Mari Tirol from the University of San Agustin College of Law. I was supposed to attend the conference in person, but because of fortuitous events, well, the trip did not push through. So that is why I'm attending virtually. So I have been assigned this topic, resilience to COVID, through the implementation of the Erasmus Plus CBHE CALESA project. So insofar as the University of San Agustin is concerned, there are two units of our university, the College of Law and the College of Liberal Arts, Sciences and Education, which are involved in the CALESA project. So Peping, Professor Jose Manuel de Torres Perea earlier mentioned the philosophy behind what we are doing right now. And just a while ago, Justice Carandang mentioned that, well, we have to be resilient. We have to adapt the change to the new normal. In fact, necessity is the mother of invention. And well, when life hands you lemons, you find some salt and tequila. No? So when COVID hit, of course, all of us did not know what to do. In fact, the CALESA project was itself, well, there was a little situation there about what to do with the project. But eventually, we found our bearings. No, we found our balance. So one of the first things that we did for the CALESA project was we requested Peping for an expert in international maritime law. And we sponsored this online lecture on international maritime law with Professor Alejandro Sanchez Frias of UMA. And this was a very well-received lecture. In fact, it was not just the students and the faculty of the College of Law which attended, but the students and the faculty of a maritime university in Iloilo City, the John B. Lacson Foundation Maritime University, also attended the lecture, and they were had very positive responses to what they learned that evening. Aside from that, Professor Peping himself conducted an online lecture for us on Acción Pauliana, and I am proud to say that among those who attended the lecture was Professor Ruben Balane himself and Associate Dean Sol Lumba of the UP College of Law. So aside from that, of course, we also sought the assistance of Peping in securing a lecturer from Spain in a seminar on domestic and international arbitration. We have sponsored two seminars of this nature already. The first one, Decoding Disputes, was on April to May 2021. So it was I think 8 weeks, one seminar every evening with speakers from all over the Philippines and also from abroad. And among the speakers, the one that Peping recommended to us was Dr. Teresa Rodriguez de las Heras Bayel of the Madrid Court of Arbitration and the Spanish Court of Arbitration. Also a lecturer that in that series was Daniel Fabio Jacob Noguera of the Charter Institute of Arbitrators in Brazil. Now, the second seminar on dispute resolution was Synergizing Settlements, which was early this year. And among the speakers was Professor Maria Salas Porras of UMA, which Peping also recommended to us. And for that, we are very thankful. Now, aside from these online seminars, which are actually not, well, they are not officially CALESA activities, but we consider them to be such. We, the University of San Agustin, together with UMA and the Ateneo de Zamboanga University, sponsored the conference on languages in the pluricultural and plurilingual and pluricultural world on 23 to 25 June 2021. This was conducted online, and there were many speakers. Many were from UMA, a few. One was from our university. Some were from the Ateneo de Zamboanga University, including our friend, Professor Claire Concepcion, who is in the panel this evening or this morning in Lisbon. Aside from that, we had another seminar, and this was hybrid. A seminar on global history and the construction of global citizenship from 18 to 26 of May 2022 in the University of San Agustin. So our professors, our lecturers came from Spain, from Malaga, Professor Fernando Wolf, Professor Antonio Calvo, and we had two lecturers from the university, Ateneo de Zamboanga, Father Antonio de Castro and Miss Maria Cristina Cañones. And we had one lecturer each from the University of the Philippines, Professor Felino S. Garcia Jr., and now Energy Secretary Rafael Perpetuo Lotilla who was then connected with the Asian Institute of Management. So many of our attendees attended in person and many more attended online during this series of lectures by our experts. Aside from that, we also participated in CALESA Manila 2022, and this was our delegation. And I'm proud to state that 4 of our students delivered papers, and 1 of our faculty members was a reactor. And the topics that they tackled were digital finance, the party list system, the minimum wage, the difference in penal sanctions between men and women in the revised penal code, and fake news and online disinformation. We are also proud to state that the Legal Education Board, our government regulator, has already approved our revised law curriculum, and we have introduced 2 new institutionally required courses, which are 2 credit units each, pursuant to our commitment to CALESA. One is on cultural properties, heritage, and tourism, because we recognize the similarities of Spain and the Philippines insofar as, well, history and culture, and about the way to propagate these heritages, if I may say so, not just for the future generations, but also for the present one. And the second institutionally required course that we will be introducing is computation law, or legal knowledge and information systems. And aside from these 2, we are introducing a new elective on alternative dispute resolution, because we are already offering alternative dispute resolution, but we find that just one subject on ADR is not enough, and so we want to introduce an elective. If you may notice, we seem to have an interest in ADR. It is because one of our faculty members is the head of the Philippine Arbitration Center in the Visayas, which is, we believe, the first and only school-based arbitration center in the Philippines. And that is why we are a little very particular with the offering of arbitration as a mode for settling disputes. Aside from that, we have acquired various equipment and software because of the grant from CALESA. To the left of the screen, you see a photo which was taken yesterday when my colleagues and I attended online the opening session. And to the right, so you will see in the monitors, there are stickers. These are actually CALESA stickers. And some of the equipment that we purchased from our CALESA funds were used during the globalization seminar last May. Now, the other equipment are, of course, not pictured here, but they are also being used by our other units, not just in the College of Law, but also in the College of Liberal Arts. Now, with respect to software, our College of Liberal Arts, Sciences, and Education has purchased software, a computer-aided language learning software. And we are considering the possibility of also requiring our law students to utilize the software to learn the Spanish language. The very least, to give them a working knowledge of the language so that they can read and appreciate the primary sources of many of our laws and of many of our commentaries in our laws. And lastly, we have here a letter that I sent to my university president concerning our proposal to him for our school to publish the Handbook on Spanish Tourism Law adapted to the Philippine Civil Code, authored by Professor Peping de Torres. So I'm very happy to report that this proposal is gaining traction because it has already received the support of our Vice President for Academic Affairs. So again, this book, if published, will be a very good partner to our offering of heritage and tourism law as a required course in the College of Law. I would just like to note, however, that this book is not just for law students, but also for the undergraduates, for those who are taking up tourism in college. Our school is offering BS in Tourism Management, and there are many other schools in the Philippines which also offer the same course or the same program. So this is one way for CALESA to expand not just in the field of legal education, but also in other fields as well. And so I close And I hope that you are able to pick up a few tips on how we can overcome COVID and move on forward, not just with CALESA, but with other shared concerns as well. Thank you very much.
Thank you so much, Dean Tirol. It's going to be our care to deliver to you our thank you tile and certificate. And obviously, you're more than welcome to visit Lisbon anytime to make up for this visit. We would love to welcome you next time in person. Thank you so much for your presentation.
Thank you.
Sticking within the time.
Thank you, Professor.
Feel welcome to keep with us for the last two presentations of the panel. I'm now handing the floor to Dean Jose Marino Filenia, Dean of the School of Law of the Ateneo de Manila University. Please, I welcome you to the podium. Yes, yes. There's also the pointer. Yeah.
Anyway, while the slides are being set up again, forgo the salutations of the second day. I'm sure we all know each other. I've gotten to know each other pretty well. So thank you for this opportunity. This particular session, in line with the theme of this particular session, which is on resilience, the title of my presentation is Ensuring No Interruptions in the Ateneo Law School's Mission during the COVID-19 pandemic. And I suppose for many of the Philippine law schools, these are going to be familiar themes and familiar sets of narrations that I will say. But I'm hoping that, I guess, for our European friends, this might be something new, alien in terms of the culture. So if I can... Again, while waiting, I don't look at this so much as a lecture or a talk rather than storytelling, which is what I'm going to, hope to embark on now. And it essentially tells the story of what we pretended we knew at the time, when in fact we didn't, in terms of what the effects of COVID was, and therefore how we would respond to something, as globally as earth-shaking as that. Okay, so this is the forward. Okay, all right. So as I mentioned, the title is Ensuring No Interruptions in the Ateneo Law School's Mission during the COVID-19 pandemic. And to be able to best start off, of course, is to tell you what the mission of the Ateneo Law School is. Certainly, we are a law school, and therefore we will teach the law in order for our students to get qualified to become lawyers. But we are a Jesuit institution, consistent with the thrusts of Jesuit education. We care for not just your mind, but for your soul. We look at students potentially as the new lawyers, not just persons who will pursue a career, but ones who will become leaders, ones who will become both spiritually and socially involved and have a wide perspective, and therefore become leaders, to influence the legal community. With that mission, therefore, it's imbued with certain fundamental Jesuit values, such as Magis. An aspect of Magis is to make sure that we provide excellent education, and also cura personalis, which is to care for the entire person of our students. And this really requires us to encounter our students, to be one with them. And that's why physical presence and face-to-face is really important to us. That is critical to the education that we provide, because what we encompass are both education, and this is our moot court room in our school, as well as formation, so that our students can know what the law is, become lawyers, and serve the people. So apart from that, therefore, that particular mission that the Ateneo is committed to, there was, of course, that threat of interruption. At that time, it was just a threat. Little did we know, well, we sort of expected that it would be actual interruption. The next slides were actually just a enumeration of the chronology, and I will just go through this quickly just to say that the point of this was that even as the Ateneo itself was preparing to what it's needed to face the crisis, the government also was doing so. And sometimes even the plans of the university with respect to what was they planned to do were affected, were itself interrupted by government decisions to essentially close down. But the directive was clear from the university that even as we would close physically, the online learning will continue with the support of IT services, and formation and social development work that can be done will also be explored, because that is our mission critical work. So the last in bullet point here was when, state of calamity, placing the entire Philippines now under emergency situation. And therefore, with that particular scenario, we had to, of course, make our decision. And in doing so, in making the decision, we sat down, as we would all do in making decisions, and we wrote down in the board, all the thoughts and that we had. This is a whiteboard in my little conference room of my office, where we put on the thoughts, what do we do, what are the premises, etc. And 2 years later, these things are still on the whiteboard. I haven't the heart to erase them. It's like a piece of history right now in my wall. In any case, the other thing that we had to confront was the student anxiety. The students as well were concerned about their health and COVID, and therefore they were understandably disturbed by certain developments. And some of the mantras, they were clamoring very much, no student left behind, which they translated to mean that if there is any student that was suffering a disadvantage, then we should all be in united with that person and to attend to their needs. They also clamored for an academic break, which is let's stop school, okay, for the moment because of COVID. And in addition, in fact, there was a clamor for mass passing. Let's stop school, just pass us on to the next level. If we were second year, pass us on to the third level or so. And there was that, There was that articulation of a sentiment from the studentry. On our part, therefore, our bottom line choices were really, do we stop completely? Do we pause so that we can regroup and find out what we need to do, or we just simply proceed? At the end of the day, we paused and had to regroup and had to see what would work for us and proceed. And the underlying basis for us to proceed was really because of our responsibilities and our commitment, both as a law school and as lawyers. For those commitments and responsibilities required us to perform certain services, both not only to our students and faculty, but to the entire legal community. And therefore, that was I guess our response to the call for academic break and mass passing. We felt that since the Code of Professional Canons tell us that we as lawyers are not supposed to agree to admit anyone to the practice who is unsuitable on the basis of qualifications, even character, that is in our canons. And therefore, we felt that we only will be able to do that if we continue to be able to continue with our education and assess our students, rather than, I guess, to mass pass. That was a decision that we had taken. And again, recognizing that our duties were not just to our students, our duties was to the legal community as a whole, to put persons of good character and qualified to practice the profession. Okay. So therefore, with that decision, we reached that decision. We said, no, we will continue. We will continue, we will educate, we will assess. In other words, people will still demonstrate to us that they have understood what the law is and the rightful application, in order for us to give the green light for them to take the next level, so to speak. So that was a deliberate decision on our part. So in order to ensure, however, that there's no interruptions, we did recognize still that it was not normal times. And therefore, our approach to pursuing had to be characterized with compassion. And therefore, our education, if I look at it in 3 phases, the first phase was really when we really, we're grappling with things. So this was really a new thing altogether. And to proceed with compassion meant that we will try our best to provide education and formation to our students with what we had. The compassion part of it, compelled us to refund certain fees paid by the students because they are not able to use the facilities of the school anymore. We made no compulsory attendance in classes and merely did it on an asynchronous basis. And also perhaps professors could provide lectures to our students. We did not give numerical grades, but instead either gave a general assessment categories of pass, or if the professor felt that you did not meet the grade, so to speak, that you would not be given a failing grade in your transcript, it'll appear as no mark, though you had to take that subject again. Any such no mark or non-passing grade would not place you in probation. In other words, you are not going to be sanctioned academically for not meeting the grade, so to speak. So we had those kinds of adjustments in the semester in which the COVID-19 actually hit. The second phase, and insofar as formation aspects, though, we were determined to continue with formation, although proceed with it remotely best that we could. And this would include not just our usual spiritual development and counseling, but certain academic traditions. The Philippines is very big on academic traditions like graduations, etc. And therefore, we said we will continue no matter with what we have. Therefore, things like this came into play. We celebrated our bar passers through an online mass. We had recorded lectures for our continuing legal education. We had the graduation look like this, where we had to wear the attire, but facing a computer. The second phase, I suppose, is when we started to get settled and started to level up. And at this time, we already required student attendance at class. So synchronous classes through Zoom largely, realizing that they would need Wi-Fi support because connectivity is not equal across the country. We were prepared to provide some support. Now we had these little devices, I don't know what they're called, but that were available to our students even when they needed it. For health issues, which was really very real, we had made some certain relaxation or flexibilities in our cut system. That the cut system is a system that sort of ensures that the students attend class physically. So we had to relax that, and generally address the reality that people needed to cope with the situation. And therefore, actually, what we've seen here was that any particular technical requirements for leaves of absence or so were relaxed a bit, and students were allowed to go on that. And generally, exam taking was done online. And formation still the same, still online, including human rights advocacies, etc., were done online. And I think the third phase I would just call now is the current normal. I still refuse to call it the new normal, wishing that things will still, change. But the current normal is that we are actually back to full face-to-face. The Ateneo de Manila is full face-to-face. Its campus is now accessible, except that the priority is for academic activities and student use. Whereas before we used to allow, for instance, auditoriums to be used by third parties for their events or so, we're not yet up to there. So priority of use. Now, by regulation, we are, however, requiring our students and our faculty to continue to wear masks and generally to keep social distance. In some sort, we've adopted what we call an adaptive mode, which is really to say that if the health situation either improves or declines, we will be in a position to shift to a particular mode that we've tested and experimented on also without, therefore, interruption. And lastly, of course, we have to continue to deal with COVID. And in this, we have instituted a process whereby the university's health services office is the one who makes the assessments. And students who are under COVID-related afflictions will be, in some sense, allowed to participate in class online, even as those who are not so afflicted can attend physically. So that's how we've been. How we've reached this decision so far to pursue our mission as seamlessly as we hoped we could. Not perfect, obviously, and this is where we are now. So thank you.
Thank you very much. Thank you very much. We move on to our very last but not least important speaker of the day. So Professor Claribel Concepcion, faculty member at the Ateneo of Zamboanga, will deliver the final presentation of this panel.
Good afternoon, everyone. Thank you for this blessing to be with you and for the day's previews. Such really is a rare opportunity, especially from someone who comes from Mindanao. So I'm very thankful, especially to Dr. Peping and to Dean Maita for including Ateneo de Zamboanga, maybe because of the so much relationship that we share with Spain, linguistically speaking. So let me now dive into this presentation. I would like to tell you that it's a series of studies actually, but because of lack of time, I wouldn't be able to present all of the highlights. Most of what I will concentrate on will be the results of the descriptive study that we conducted with the college students. Although we also conducted a survey with the graduate students and the faculty members separately. We conducted interviews in order to back up the data that we were able to collect out of the surveys. So when the pandemic hit us, especially in March, on March 16, 2020, we were caught unprepared, and I think you would agree in some respects. And for the Filipino parents, one of the proudest moment that they could ever have, and they can ever have, is really the graduation. It's something that they can really enjoy, something that they can bask in, but the pandemic ruined it. So when there was the shutdown, it got most of us worried, especially the administrators, not so much for the faculty members, because we believed that our faculty members were already prepared to handle online learning systems. But we were more afraid of the repercussions that our students could face. Why? Because we have a lot of students who come from the different islands. Jolo, which is very infamous when it comes to peace and security, Tawi-Tawi, and Basilan. In these areas, there are two problems that people always face, and these are the lack of internet connection and the lack of power. And in Zamboanga City, we also face the same problems, although it's not really that worse. We experienced 2 to 4 times brownout, and I hope that this will not discourage you, because maybe some of you are already thinking of going there, but it's really not that serious, because even if sometimes the brownouts are frequent, they're not that protected in Zamboanga City. So what we needed to do, especially the administrators, was to sit down and brainstorm for the ways forward. And we were afraid of the different devices that our faculty members were having. And so we surveyed them, and here are the results. So I'm going to run through the different slides that I have, because there's no more time. So we had, at that time in 2020, 182 faculty members, and 101 participated in the survey. And the analysis was based on the 55.49% of the total faculty members of the higher education institution. We also tested their technical capability, just to be very sure, and to discover what else the university could help them with. And the results here show that in terms of technical capability, 96.04% owned a laptop and or a desktop computer. And you see here the resources that our faculty members had. But some of these were no longer workable. And so what the university decided to do, because there were no more classes, was to lend the equipment of the university. So some faculty members and the staff took home with them the laptops, printers, and other kinds of devices just so the work could be continued. And the students also suffered the same problems, but more. So on the overall classroom management systems, the faculty members were also tested, and results revealed that 57.43% had experience with the classroom management. But even so, we needed to prepare them more, because even if they were aware of some of the learning systems that could be used online, some of them were not confident. And this was really the first time where the massive online teaching would be conducted. And you see there the results. These two. So these were the common technologies that our faculty members used, the E-class at Modo. And of all of these, the E-class had a high percentage, and but we had some problems there because whenever there was a brownout, it was so heavy to open our LMS. So most of us, especially the students, shifted to Messenger and Facebook because it was easy to convey information and to do the flipping of the classrooms. You know, we also made use of the email for the different modules that we prepared for them. So you see there the tab reasons for the preference or preferences. And here are their reasons for using those kinds of technology. But when it came to quizzes, we had to do more and look for other systems which could really be relied upon, especially for comprehensive exams. And the board exams in preparation for the licensure of the medical course. So here were the reasons for not using those kinds of technologies presented earlier, right? So you see here on this slide that there were differences in the results. So 47.06 of the faculty members have experienced facilitating online discussions. So out of these results, allow me to just, skip some of the slides. We had to prepare the training sessions, for our faculty. And okay, yes. And and so what we had to do was to engage our faculty in the different trainings, all right? And trainings were applied at the Commission on Higher Education, which earned us CPD points. And it is here where I would like to probably call the attention of some of the people in PhilJA, because it's the clamor of faculty for the CPD law, which is Republic Act 10912 to be repealed, because many in the tertiary institutions feel that it is a bit unfair to require faculty members in the higher education institutions, because many are expected to give trainings rather than to attend training. So it has been their clamor, and it has been so difficult for us to receive CPD points. Oops. So the CITS also made some preparations for classes. So you see here the preparations that were done. And because faculty members also had challenges in technology, we were given a load, on a monthly basis, just so we could address the problems of internet connection, because many faculty members still did not have a good internet connection. In fact, it was only when the pandemic started that some faculty members decided to apply for the fiber connection. They tried much earlier, but it has been very difficult. And I think the warnings that were given by our president were really good, because they started doing something about this challenge. So we created a primer, and we have continued to create learning packets and other kinds of continuity plans for our students and faculty members. So I'll just skip them. And then just show you some of the training courses that we have come up with for our faculty members. All right. So I was saying a while ago that I would concentrate on one of the surveys conducted, and the objectives of these survey were the following: measure the learning experiences of the Ateneo Zamboanga University graduate and undergraduate students, and then draw patterns and insights of students' feedback on the university's flexible online learning teaching approach, and then provide general recommendations in the continuing implementation of the flexible online learning teaching approach. And we use this as one of our data collection methods here. So finally, the data was collected, analyzed, and analyzed using a multivariate analysis. And a multivariate analysis is a process of involving multiple dependent variables resulting in one outcome. So we observe ethical guidelines in collecting data from the different students and faculty. And this was our questionnaire. So 10 questions on the demographics, 25 opinion statements in the form of 6-point Likert scale. And those were the options given to the respondents of the study. And here are the summary of findings. Number one, the overall online learning experience of graduate students was very positive during the first semester of school year 2020-2021, despite the challenges that the university, faculty, and students and the wider community faced. Majority of the students were aware of the ATSU RIDE learning approach. This was created in response to the pandemic. So RIDE is actually an acronym which stands for the following words: responsive, independent, guided, holistic, and technologically assisted kind of learning. And students also agreed that teachers completed the course online and were informed of how they were assessed. Traditional face-to-face learning was still more favored by the graduate students than the online learning. Of course, I think nothing can beat that. For the undergraduate, overall online learning was equally positive, but yes, equally positive. Majority of the students were also aware of the learning right approach. And students who were more aware of these were more likely also to agree that they had an overall positive learning experience. Here too, students could rely on their teachers for help, appreciated their efforts for being organized, and they enjoyed the flexibility of online learning, but they really experienced poor internet speed and reliability. And the school really aided the students, especially the education students. We had this program called the Pan Kada Dia, and we converted it into the Load Kada Dia. The school also lent its equipment to the students, but created modules for those who did not have the internet and sometimes had also problems about power. Here. So majority of the students found online learning and teaching less enjoyable, and its quality much less than the traditional face-to-face learning. Some notable observations I would just choose. 70% of the students enrolled for 8 to 10 subjects, and they found this very heavy, even if we divided the semester into 2 quarters. So, and each quarter only had 6 sessions at the beginning. More than a quarter spent more than 9 hours a week to accomplish academic tasks, and this really weighed down on the students. And home was the most common location, but home here didn't mean the individual homes of the students, but also the homes of their relatives. And sometimes even if they answered homes, they were outside literally of their homes. They were on the streets just to be able to get good internet connection. And Zoom was the most used platform. Students didn't like Google Meet because it was limited in features. And last September, just the second week of September, the university decided to cut its subscription of Zoom accounts, and it got again the faculty members worried, and so we asked the university to continue subscribing because we have not yet gone back to full face-to-face. Okay. So more study hours, less positive experience. Nearly 1 in 3 did not own access to a device, and just 2% experienced excellent internet reception. So these are already the recommendations. So like 1, regular monitoring by deans and department chairs of teachers' classroom practices, ensure the number of hours per synchronous session is followed. You know, we went overboard simply because we were cut many times by internet, you know, sometimes fiber connection and power interruptions. And it was really difficult to monitor the time online. Assessment strategies should be within bounds, measure the intended course outcomes, and meet specific department guidelines. And we really lowered the standards so that we could adjust with the different situations that the students had faced. So here. So the rest, I think I will just, yeah, leave them like that. And if you want, I will pause there so that you can capture at least some of the recommendations. Yes, thank you so much.
Thank you so much. I therefore concluded the session. I thank you all for the patience on the delay of our schedule, and I address a big thank you to all our speakers. I think now we move on to the program because we have a student's performance for you.
Thank you, Professor. Dear guests, please take your seats. The closing ceremony is about to start. We now invite our very own music pride, the Juristuna of Nova School of Law, whose students will perform for us all, sharing their passion and talent for music and friendship. We reached the end of this academic event. We have been honored to be your host. We hope you enjoyed as much as we did. And for the farewell message of this CALESA conference, we welcome to the stage Professor Francisco Pereira Coutinho, member of the steering committee and NOVA partner representative of the CALESA project.
Thank you so much. Honorable Chief Justice, dear justices, dear colleagues from the Philippines and Spain. It was an absolute pleasure to have you all here during the last 3 days. I'll be very brief. We are very late. I need to make this a big word of thank you to Guillermo. He's right here. This was not possible without his immense effort during these 3 days. I was incredibly lucky of having him, also my two colleagues, Julia and Athena. They are helping all along this process. So thank you so much, both of you also. And of course, in all these events of the CALESA project, thank you so much, Pepping. Where are you? There you are. We did have a wonderful time in Manila in June, and we were really looking forward to organize this event. And during the coming year, we'll probably go also to the Philippines again, and we'll be more than delighted to welcome also our colleagues in Dublin Deusto, and of course, Malaga in the end, in the end of 2023. So thank you so much. And now we will formally end with a typical Portuguese taste of Porto wine. So you're all welcome to do this final taste to this wonderful conference. Thank you so much.